Great, thank you. Welcome everyone to the March webinar, a collaboration of the Federation for Children with Special Needs and the Recruitment Training and Support Center. I am Eileen Sandberg, one of the Recruitment and Training Support Specialists at RTSC. Today's webinar is entitled School Discipline Reform, What You Need to Know. Our presenter is Elizabeth McIntyre. Ms. McIntyre is a staff attorney at the Greater Boston Legal Services and director of their School to Prison Pipeline Intervention Program. Please type your questions for the webinar into either the chat or the question and answer section. Handouts for this presentation will be distributed after the webinar. Welcome, Elizabeth.
Hi, folks. I'm so glad that you are all able to join us during this very weird, very difficult time. I'm hopeful that today we're going to talk about some school discipline and special education information that will be helpful again when our schools are back in session. As we go through the presentation, we'll pause occasionally to take questions. Eileen is going to keep track of those questions. So if you have them, you can go ahead and enter them into the Q&A, and I promise we will answer them throughout the presentation. Okay, so as Eileen said, here at Greater Boston Legal Services, I represent poor kids with disabilities in school discipline and related special education cases. And I think before we really dive into what the rules are with school discipline, it's helpful to sort of take a step back and think about what the school to prison pipeline or the cradle to prison pipeline is, because this is really a term that advocates and caregivers and kids have thought about for a long time, but has really entered the zeitgeist just in the past maybe 15 years. Can you go ahead and click through, Renee? Get this, or Eileen. Perfect. So what we're talking about is, if you want to make the whole slide, all the text on the slide show up, I think that's probably easiest. There we go. Excellent. So this is sort of, when we look at these numbers, this is what we're talking. Oh, got to go back. Thanks everybody for your patience as we try to make all this technology work. There we go. So when we think about the cradle to prison pipeline, this is really what we are talking about, is denying really the most vulnerable kids in the Commonwealth the opportunity to gain an education. A thing that I think is helpful to know about school discipline, school suspension, and the cradle to prison pipeline is that school discipline through suspensions and expulsions was not always how folks responded to disciplinary problems at school. We saw a huge spike in suspensions and expulsions in the 90s, and I think knowing some of that context is helpful. In the 1990s, we had the Columbine school shooting. And when that Columbine school shooting happened, educators reached out into the ether to think about, what can we do to prevent this from ever happening again? And because it was the 90s, very unfortunately, the idea that these educators glommed onto was the idea of broken windows policing. And broken windows policing is this really discredited theory of policing that is about saying, well, maybe if we arrest folks for very minor offenses, things like loitering, like breaking a window, like being near broken windows, then we'll have fewer murders. And what happened after the Columbine school shooting is that educators took that idea, maybe if we arrest people for breaking windows, we'll have fewer murders, and applied it to kids in schools. And thus this idea of zero tolerance was born. And zero tolerance is really the idea that maybe if we suspend kids for wearing the wrong color belt, we won't have another Columbine. And it did not take very long for folks to conclude that that idea was really not working as planned. And instead, what we are seeing is that our most vulnerable kids, our kids of color and our kids with disabilities, were being pushed out of their school community. So in Massachusetts, this is 2017, 2018, Black students lost 66 days of instruction for every 100 Black students. Students with disabilities, 44 days of instruction. Latino students lost 31 days of instruction. White students lost 14 days of instruction. So what that tells us is that this zero tolerance idea really resulted in kids with disabilities and kids of color being denied their opportunity to learn. And as we moved through zero tolerance, we learned really the devastating ramifications that that has for kids. So we know that in Massachusetts, students who are suspended are more likely to repeat a grade, more likely to drop out of school, more likely to be arrested before they turn 18. And in Massachusetts, one of the best predictors of arrest post 18 years old is arrest pre 18 years old. So we have this very clear pattern where kids with disabilities, kids of color, and particularly our kids of color with disabilities are deprived of their education and really moved from repeated suspension early in life to repeated incarceration later in life. That is how the Cradle to Prison pipeline operates in Massachusetts and around the country. Next slide. So I think it's helpful to hear what this is like for kids. And I know that, you know, many if not all of you are working with kids and know what this does to students. But I think, you know, because part of my job, a huge part of my job is working with kids, I see part of my job as really trying to amplify their voices. And so in contexts like this, where it's me talking at you, not one of my clients, I think it's helpful to know what these kids are saying here. So these are all from surveys that I've done after trainings for kids. And I think it's important to note that with two of these, the first quote and the last quote, we're really talking about kids who found schools that were able to help them. And that means a lot. So first is from a student who was really struggling, and then all of a sudden that school started doing so much better. And so we jumped in and said, like, okay, let's reconvene the IEP team. Let's figure out what's going on. What can we change? And what it really was there was this one staff member who really clicked with this student. And that made a huge difference. And this middle quote, I don't see the point of going to school if they're just going to tell me to leave again. I might as well just not go, I think is so devastating and is just such a good example of what the school to prison pipeline does to kids, is that as kids are repeatedly excluded from school at a certain point, they're going to conclude that it doesn't make sense for them to continue to go. And then this last line, you know, students who really start to believe what we tell them when we repeatedly suspend them, which is that they can't do this, that they need to find something else. And that, you know, that is really the direct harm that this does. So all of that, that's sort of all of the bad news. The good news is that Massachusetts looked at really the devastating ramifications that zero tolerance had on our most vulnerable kids, and our state legislature and our governor acted to try and prevent that from happening. And in 2012, Massachusetts passed really groundbreaking school discipline reform. And this groundbreaking school discipline reform became effective fall of 2014, so almost 5.5 years ago. Perfect. Thanks for changing the slide. That's great timing. And so what I want to talk about now is sort of what this law did. And we need to start, whoops, can we go back? Perfect. We need to start by talking about what a suspension is. So the first thing to know is that suspensions can really be divvied up into short-term and long-term, in school and out of school. So a short-term suspension is when a student is suspended for more than 10 days cumulatively over the course of a school year. A long-term suspension is if a student is suspended for more than 10 days cumulatively over the course of the school year. So what that means is if a student is suspended for 5 days in September and then another 4 days in January, so that's 9 days, and then is suspended for 2 more days in early March, let's say, that last 2-day suspension counts as a long-term suspension because we've now hit over 10 days. Now we have an in-school versus out-of-school suspensions. So an in-school suspension, generally across the state, we're talking about a suspension where a child is held out of their classroom for approximately more than half the day. DESE's guidance on this, the state's guidance on this, is that it doesn't have to be literally to the minute the child is out of school for more than half the day. If we have a situation where you have, say, like a 5-year-old child and the school is set up such that every time a child speaks out of turn or doesn't respond to a redirection, the child gets sent out of the classroom to process and come back in. Let's imagine that the child is in the class for 5 minutes and then sent out and is out for 10, and then is back in for 3 minutes and then talks out of turn again and is sent out again. And this goes on and on and on throughout the whole day. That is going to count as an in-school suspension, even though it might not be to the minute more than half the day. Always more than half the day counts as an in-school suspension. An out-of-school suspension is when a child is removed from the school premises prior to the regular end of the school day. So what that means is if the school day ends at, let's say, 3 p.m. and at 2:30, the principal calls the caregiver and says, like, hey, Renee's having a really tough time. Can you just come pick her up? And the parent gets there at 2:45 and takes the child home 15 minutes prior to the end of the regular school day. That counts as an out-of-school suspension. Are there any questions about that? Short-term and long-term suspensions in school, out of school?
We have a question. Yes, actually, we have a couple of questions.
Okay.
But I might hold a couple until we get closer to the section that I think is on that. But the first one is, a student is a 16-year-old at a local public high school and has been suspended 10 days this year. The district is stating that no manifestation determination meeting needs to be held until he reaches the 11th suspension day, and that they have 10 days after that 11th suspension day. Are they correct?
They are. When a district is not required to hold a manifestation determination review until they hit the 11th day of suspension in a school year, and then they have 10 days from that 11th day to hold that MDR. We'll also talk more about manifestation determination reviews shortly, but the short answer is yes, they're correct. Any other questions?
I think that's it.
Appreciate it. Okay, so that's okay, great. So that's short-term and long-term in school, out of school. An indefinite suspension, this is when a student is suspended pursuant to a felony charge. Talk more about that in a minute. And an expulsion is when a student is long-term suspended for more than 90 days in a school year. And sometimes that can get confusing because sometimes schools say, particularly if anybody's worked with Boston often uses the word expulsion when they don't mean expulsion. But expulsion as defined by law is a long-term suspension more than 90 days. Okay, next slide. Okay, so before we sort of get into what rights kids get when they are suspended, the next thing that we need to talk about is the different kinds of things for which kids can be suspended. So these should be sort of broken up into 3 buckets. That's how the law thinks about them. So the first bucket is having a weapon, having drugs, or assaulting staff. The second bucket is about felonies, and the third bucket is everything else. And the law is slightly different in different places depending on which of these buckets you fall into, the kid falls into. So we start with bucket 1, weapons, drugs, assaulting staff. Weapons should be fairly straightforward. It includes some knives, but not all knives, but most other things that you would think of as weapons. With drugs, important to know that we really are talking about controlled substances here. This continues to include marijuana. It does not include nicotine or alcohol. So if a child has a vaping device at school with nicotine but not marijuana, that's not bucket 1. That would be bucket 3. Assaulting staff. Assaulting staff requires intent. So oftentimes we see situations where a staff member was injured, but the child did not at all intend to injure the staff member. And sometimes those kinds of cases can fit into bucket one, but often not. So for example, if we think about a 10-year-old kid who is feeling very anxious in like an enclosed space, think like a planning center or a timeout room, and that 10-year-old kid wants out of that planning center or timeout room. So, but there's a staff member who's standing in the doorway and refusing to let the child leave. And the child starts to run out of that place and sort of in their dash past the staff member to get out the door, they sort of accidentally brush the staff member. So that's not going to count as assaulting staff. That's going to have to be a bucket 3. Contrast that to, let's say we have a same kid, but let's imagine that they are getting into a fight with another student and a staff member restrains the student to prevent them from punching another child. And while they're in that restraint, they scratch or bite or otherwise fight to get out of the restraint. That is going to count as assaulting staff because the child is trying to get the staff member to let them go and therefore is assaulting them. So that's sort of that distinction. Next, bucket 2. So this is felonies where the student's continued presence at the school would have a substantial detrimental effect on the general welfare of the school. What that means, goodness only knows. The legislature, really did not write that particularly clearly. But the way I think about it is that there's got to be some kind of significant connection between the felony that the child is charged with and something at school. So to give some examples, like let's say that a child gets into a fight at a T station on their way home from school with other students in the school, and the police break up the fight and the child kicked someone and is charged with assault with a deadly weapon for kicking someone with a shod foot. In that case, that probably, if those kids are all in the same school, that's probably going to say, okay, this could have some kind of effect on the welfare of the school. If, on the other hand, you've got a kid who, stole something from a gas station that was worth a lot of money, but the child has no history of stealing anything at school, there's no reason to think they would steal anything at school, they didn't steal anything from anyone at school, I would argue that's not going to cut it. I also want to make sure folks know, if you have a case where a student is charged with a felony and the school district or charter school is trying to exclude that child from school, please talk to the child's delinquency attorney, because we certainly don't want any kids saying anything during a suspension hearing that could complicate their criminal case. The third bucket is everything else. So a thing that folks often want to know about school discipline law is, what can't kids be suspended for? But unfortunately, school discipline law is sort of like criminal justice law in that in the same way that nearly anything could be criminalized, nearly everything can sort of be made into a suspendable offense. So the law doesn't say, for example, you can't suspend a child for dress code violations, or you can't suspend a child for talking back. Instead, what the law says is, if you're going to suspend a kid, we're going to make it hard, we're going to make it complicated, and we're going to hope that that deters you and prevents students from being suspended, especially for sort of these everything else bucket 3 offenses. So those are the 3 categories. Bucket 1, weapons, drugs, assaulting staff. Bucket 2, felonies. Bucket 3, everything else. Any questions about that before we move on?
Sorry, it takes me a minute to unmute. Okay, just something I think that you've already covered, but if the school calls the parent to come and pick the child up, that is an out-of-school suspension, correct?
Correct.
In that case, are they not required to have a suspension hearing? Are you going to get to that?
I am going to get to that. Yes, it is an out-of-school suspension, and they are required to hold a hearing, even though they don't always think they are.
Okay, thank you. I got one more question. Let me just see.
Mm-hmm.
If the parent is asked to pick their child up due to behavior issues, but the school says they are not suspending the child, does it actually count as a suspension?
Great question. Yes, it does. An important thing to remember here is that the law defines what a suspension is. So it really doesn't matter what a school calls it. I've heard schools call these therapeutic dismissals. I've heard schools call them just take a break. If a school is removing a child for behavioral misconduct or disciplinary issue prior to the end of the regular school day, I don't care if they call it a field trip to Hawaii. What it is a suspension. Yeah.
If a child assaults another student, not staff, which bucket does that fall under?
Bucket 3. That's everything else.
Okay. This one's for me because you and I have talked about it, Elizabeth. What about things like the student postures and pretends they're going to hit someone, or spitting?
Yes, that is going to be an everything else category. So posturing or things like that, that's going to be everything else. Yep.
What about spitting on a staff?
Spitting is a little bit more complicated because it depends on the particulars of the situation. Technically, an assault is an unwanted touching. I would say that in most situations, if a school district is trying to suspend a child under bucket 1, saying that spitting on a staff member is assaulting them, I would love to hear about it. Because I think most of the time that is not what is intended by that statute. I think that is a situation where folks who represent schools may tell you, we think that counts. I would tell you, I don't think that it does.
Okay.
Okay.
Okay then.
All right. Okay, so now what I want to talk about is all of the different rights that kids have. You have most of these rights across all 3 buckets, though not all of them, and the timeline on which they happen can be a little different in some circumstances. So bear with me as we go through this. The first substantive right, and really a huge change that the state made when they passed school discipline reform, is they said for these bucket 3 offenses, so not weapons, not drugs, not assaulting staff, and not felonies, before you can long-term suspend a child for a bucket 3 offense, you must try something else first. And that effectively ended zero tolerance. That said, principals are required to use discretion. They can say things like, anytime a child gets in a fight, we automatically suspend. No, we don't do that anymore. We don't have automatic suspensions. That's the first thing. So that is that alternative to exclusion. Kids cannot be suspended for a bucket 3 offense without the district, can't be long-term suspended for a bucket 3 offense without the district trying something else first. Just as a side note, state law provides a floor, not a ceiling, meaning that the state says, hey, school districts, here's the minimum you must do, but you are free to do more if you want to. And so Boston is one of the districts that has chosen to do more, to be more protective. And this is one of those areas where Boston is more protective than the rest of the state. So in Boston says, before you can suspend a student for a bucket 3 offense for a suspension of any length, short-term or long-term, in school or out of school, you must try something else first. But everywhere else, you only have this protection prior to a long-term suspension. So that's the first thing. Second thing is the district has to provide what we call written and verbal notice. So written notice, we're really just talking about a letter. Why as lawyers we have to call written notice instead of just a letter, I don't know. But as in this written notice, it has to say, hey, caregiver, we're thinking about suspending your student. Here's for how many days. Here's why. Here is when we are thinking of having this suspension hearing meeting to talk about this. Does that time work for you? If the caregiver or the student does not speak English, then that written notice has to be in the language that the caregiver and the student speak. So that's the first step, written notice. Then the district has to provide verbal notice. So this means calling the family and saying, okay, we are going to have a suspension hearing for this particular kind of reason. Here's when we'd like to have it. Does that time work for you? If family doesn't speak English, then they have to make this call with an interpreter. With this timing of the hearing, the district has to accommodate the parent's reasonable request to schedule the hearing. So that means if the caregiver says, look, I don't get off work till 3, can we have the hearing at 3:30? That is perfectly reasonable. If the caregiver says, the only time I can do a hearing is 8:30 at night, that's probably not reasonable. So that's the second right, written and verbal notice. Next, the district has to hold a hearing. So a hearing is not where the family comes in and the school says, okay, you're suspended for X number of days. Here's why. Thank you very much. We'll see you on Monday. That is not a hearing. A hearing is really the student's opportunity to be heard. That means that it is the family's opportunity to say, look, I know you thought you saw that, teacher, but actually, remember how it was dismissal time and there were 1,000 kids running in every direction and you were talking to so-and-so about such and such and you didn't see what you thought you saw. Here's what actually happened. Or it's an opportunity for the family to say, you know what, that did happen, but we're dealing with an eviction this week. This is an extremely difficult time. Please don't suspend my kid. Or it's an opportunity for the family to say, okay, yes, this did happen this particular way, but it clearly happened because of this child's trauma history or autism or what have you, and a suspension is really not going to be helpful for them. They really need to be in school, right? So it is truly an opportunity for the family to share their side of the story. That's really important. Sometimes I've seen schools walk into hearings with the decision notices already written, and that means it's not a hearing. It has to be a true opportunity for the family to be heard. So that's alternatives to exclusion, only with long-term suspensions unless you're in Boston. Written notice, verbal notice, and a hearing. Those things always have to happen for any out-of-school suspension, short-term or long-term. Now, one question that of course comes up at this point is whether or not a child has a right to stay in school prior to a hearing happening. And on this issue, I'm going to tell you that there's some disagreement among lawyers who represent kids and lawyers who represent school districts. So I'm going to start with what the rules are for bucket 3, okay? So for bucket 3, kids generally have a right to remain in school until the hearing happens. So if we're not talking about weapons, if we're not talking about drugs, if we're not talking about felonies, kids generally are going to have the right to stay in school until the hearing happens. The exception to that is something called emergency removals. And what an emergency removal says is that even with bucket 3 offenses, principals may remove a student before the hearing happens if a couple of things are true. First, it has to be the case that the school district or that the child is so dangerous or so disruptive that very little learning is happening in the building. That's the first thing. The second thing is that the school district is that there's nothing else the school district can do to help ameliorate that danger or disruption for the student other than sending the student home. The third thing has to be, there has to be a safe way to get the student home. So dangerous or disruptive, nothing else the district can do to fix that danger or disruption, and there's a safe way to get the student home. Now, if you think about it, there are really very few bucket 3 circumstances where that is going to be the case, where we're not talking about weapons, drugs, assaulting staff, or felonies, but somehow the child is so dangerous or so disruptive that the school day has really ground to a halt and there's nothing else that can be done to calm the child down, and there's a safe way to get the kid home. Most of the time, if one of those 3 things are met, it means the child's going to need emergency mental health care, or the child's not safe to go home, or there's something else the district can do. What that means is that if a child is really struggling, like let's imagine we have a 12-year-old who is really struggling, who is having some kind of tantrum at school, likely because of their disability, they call the parent, they say, come on parent, we need you to come pick the child up. But then while they're waiting for the parent, the child sits back down with the math teacher and the two of them start working on a problem again, and the child comes down, and by the time the parent gets there, the child is calm. That means that that emergency removal standard is no longer met, and that child gets to stay in school. So does that make sense to everybody, that emergency removal standard? Any questions about that?
We do have a couple of questions. One is back from your previous slide. What is considered a weapon in bucket 1? Is a shod foot a weapon?
No. A shod foot is considered in the criminal context. A shod foot is considered a dangerous weapon, but not in the school discipline context. A shod foot is not a weapon. If somebody kicks somebody, that's not a weapon. A weapon is going to be things like, most knives, a gun, nunchucks, things that we would think of as weapons.
Okay. Next question. This child is on an IEP with a diagnosis of emotional disturbance, and mom is called regularly. I'm sorry, I'm seeing a poll here. Oops. Mom is called regularly by the school to pick him up because he's so disruptive to the class. The mom insists he needs a therapeutic placement, but the district says no, they can handle him, but they can't. Should she just refuse to pick him up?
Yes. So what I will often practice this with caregivers, is sort of role playing. I'm going to be the principal and somebody else going to be the caregiver, to say, you can even say, my understanding is that my child has a right to remain in school unless you're going to schedule a suspension hearing. If you want to schedule a suspension hearing, you can send me a written notice. Otherwise, I'm not picking my child up. And I always advise folks, like, it's not going to be helpful probably to get into a fight with them, with the district folks on the phone. So you can just explain that. If you want to schedule a suspension hearing, please let me know. And then I suggest folks hang up. And I know that can feel scary, but it is true that the child does have a right to be in school, and districts, too often are taking advantage of parents worrying about their kids instead of doing the right thing, which is supporting the child's disability.
Okay, next question. I've been to many manifestation meetings. My students have social and emotional disabilities. I explain that their disabilities are driving their inappropriate behaviors. Have only convinced the team a few times. Mm-hmm. My concern is that the majority of the team consists of school staff, and they vote in favor of denial, using his disability as a reason. Mm-hmm. Denial of using his disability as a reason. Do you believe that is fair?
I'm sorry, Ellen, can you ask that one more time? You're sort of saying, like, do I believe it's fair that they are saying we don't think of it's a manifestation of his disability because of the child's
Correct.
Disability?
No, they're saying they don't think it's a manifestation of the disability, but the team consists of school staff.
I see.
It's difficult to persuade them that it's a manifestation, if I'm reading the question correctly.
Got it. Yes, it is. I think, so at the end, we're going to sort of talk about, like, what to do when the district doesn't do what they're supposed to do. So I think I would file that under, like, what do I do when the district won't listen to me, or when the district won't do that? So I will answer that sort of as we get a little further down the line.
Okay. Next question. Are children with a presumptive disability prior to formal education evaluation afforded the same rights in disciplinary matters as children with an approved IEP?
Good question. That leads, Eileen, can I ask you, are there any questions about the emergency removal standard? And if not, then I'll talk about the manifestation review.
Okay, next one. What if the staff are saying that the child is going to be disruptive at this or that time, even though he's calm at the moment? Is this a case where the parent can say, call me if that happens?
Yes, absolutely. That is not emergency.
Okay.
Okay, so then let me move to manifestation determination reviews, or MDRs, and talk a little bit about how those work, how they're supposed to work, and how they sort of work. No, you can go back to the other slide. We're still on MDRs there.
Sorry.
No, there we go. Excellent. So, because I want to answer the question about what about students who are currently being evaluated. Excuse me. So the first thing to know is sort of what a manifestation determination review is, what it should look like. Then I will talk about who should get a manifestation determination review. So a manifestation determination review is not a hearing. It is a special kind of IEP team meeting, and it is convened when a school district has suspended a child with a disability for more than 10 days cumulatively over the course of the school year, including in-school and out-of-school suspensions. So if a child is out of school suspended for 5 days, and then in-school suspended for 3 days, and then out of school suspended for another 3 days, that last 3-day suspension means we hit day 11 and the child is entitled to a manifestation determination review, an MDR. At the MDR, the IEP team is trying to answer 2 questions. The first question is, does this conduct that we want to discipline with long-term suspension, or is it related to this child's disability? Or is it the result of our failure to either have a good IEP or 504 plan, or to implement a good 504 plan or IEP? So those are sort of the 2 questions. Is it related to the child's disability, or is it related to our failure to support the child's disability, basically? If the answer to either of those questions is yes, the district may not suspend or expel the student, period. It doesn't matter what the child is accused of doing, they cannot suspend or expel the child. It is true that if the principal believes that the child returning to the school would cause serious bodily injury or death, so very, very, very serious, then the school may remove the student to a private therapeutic day school for 45 days for an extended evaluation. But even then, they can't suspend the student. So that is the power of a manifestation determination review, and that is why it is so critical for caregivers who are being asked to pick up their kids day after day after day, or when kids are being held out of class day after day after day, that the district is marking those days as days of suspension, because if they're not, then we're never going to get to day 11, and this MDR protection is never going to kick in, and that means the child's going to continue to be excluded when they really should not be. So students who are entitled to MDRs include students with IEPs, students with 504 plans, students for whom an evaluation had been requested before the incident that caused the long-term suspension. So what that means is, let's say a parent requested an evaluation on Monday, and the district really didn't get their act together. They didn't give the parent the consent form. And then on Friday, so 5 days later, the child has some kind of incident at school. The district says, okay, we're going to suspend that student for, let's say, 15 days. That child should get a manifestation determination review because the parent requested the evaluation prior to the disciplinary incident. If, however, let's imagine the incident happened on Friday and then the parent requested an evaluation the following Tuesday or the following Monday, then that child, in most circumstances, is not going to be entitled to an MDR because the caregiver requested the evaluation after the incident. However, there's one other sort of situation in which a child is entitled to an MDR even when the caregiver had not requested an evaluation prior to the incident. And that is when the district is deemed to have what we call a basis of knowledge that the child has a disability. Basically, it's a situation in which the sort of law looks at the school district and says, okay, maybe you didn't officially know that this child had a disability, but if you didn't officially know, you should have known. So you either knew the student had a disability or you should have known the student has a disability. That, by way of example, might be like if a child is getting ADHD medication from the school nurse every day, and the teacher is aware of this and like sends the kid out, then that school knows that kid has a disability, and therefore that child is entitled to an MDR, even if nobody has requested a special education evaluation. So kids who get MDRs, just to recap, kids with IEPs, kids with 504 plans, kids for whom the caregiver requested an evaluation, or kids where the school either knew or should have known that the child had a disability. Those are the folks who get MDRs. Questions about that?
Quick question to start. There are students who have ADHD and take medication who have not been given a 504 or an IEP.
Mm-hmm.
Would that be considered, even if they've been evaluated? If they've been evaluated and denied an IEP, would that be considered the school knowing?
Great question. So if a child has been evaluated for special education and found ineligible, then that child does not get an MDR. So even if those other things are true, the child does not get an MDR if the child has been found ineligible for special education in the past.
Okay. Is there a hearing for all suspensions, meaning not after the 10th day? So for each suspension, whether in school or out?
Is there a hearing for every suspension?
Yes.
So there is a hearing for every out-of-school suspension. The district must hold a hearing for every out-of-school suspension. For in-school suspensions, some districts like Boston choose to hold hearings even for in-school suspensions, but all the district is required to do with in-school suspensions is to provide sort of rudimentary notice and just giving the opportunity of the student to say, like, that didn't happen the way you thought it happened, but they're not required to go through the whole formal hearing process. But notice and hearing are required for every single out-of-school suspension.
Okay. What if a student is at a school event, such as a school dance, and has a fight with another student? This happened for a student with a disability, and the school issued an out-of-school suspension for 2 days and in school for 1 day. This is for a student without any history of fighting or being suspended. What are your thoughts on that?
Mm-hmm. Well, I mean, generally, like, my thoughts as a person and as an advocate are that we really know that suspensions don't fix problems, they make them worse most of the time. So certainly unhelpful for the school to be suspending a student for that kind of conduct. But if they follow the notice and hearing procedures, so if they sent written and verbal notice to the family and they scheduled a hearing and the student had the right to remain in school until the hearing happened, that would be legal. If they didn't do some of those things, it would be illegal. This is sort of like the point that I mentioned before, which is that, districts can suspend kids for most offenses, including things that happen at school dances, but they have to follow the process. Does that make sense?
Okay. If a student is removed from their classroom and sent to another classroom, such as a buddy room, is that considered an in-school suspension?
Yes, I mean, depending on how long the student is there. It's in-school suspension is defined from removal from the student's regular classroom. Mm-hmm. So yes.
Okay.
Okay, great. Next, I'm gonna just note that for appeals, so students can appeal any long-term suspension to the superintendent. In Boston, you can appeal any suspension, short-term or long-term, but otherwise it's just long-term. And then last, I want to talk about, before the 2012 discipline reform, students could be suspended or expelled and then sort of be out of luck. They did not have a right to access education anywhere in the Commonwealth except through special education. That was changed in 2012, and we said, all right, even if a student is suspended or expelled, they are going to continue to have a right to some kind of education. So the first thing we said is that if a student is short-term suspended, so 10 days or fewer, that student has a right to make academic progress. That means is likely that the student has a right to their work. So that means that if a student was supposed to conduct a presentation and they were suspended on the presentation day, the school needs to figure out some way to accommodate that, whether it's having the student do the presentation for the class a different day or just for a teacher. But to figure that out, you can't academically penalize a child because they miss a day of school because of suspension. They're entitled to their homework, their classwork, an opportunity to get caught up. Then the law said if a student is suspended for more than 10 days over the course of a school year, we recognize that that long-term suspension is going to mean that a student is going to need some instruction, right? That you can't just give a child who's been suspended for a month a packet of work and tell them, good luck, hope you can figure this out, right? Kids need some kind of instruction if they're going to be out for that long period of time. So if a student is long-term suspended more than 10 days over the course of the school year, then they have a right to what we call alternative education. Sometimes that looks like brick and mortar buildings. Some districts have actual physical alternative ed schools that kids can go to. Sometimes that means some combination of online learning and tutoring. It depends on the student's particular situation, but you have that right if you are long-term suspended. Okay, next slide. Okay, so I just want to go through a couple of, things that I have noticed are often that school districts sometimes get wrong, just so that I can make sure that we clear them up and make sure that you all are clear. And then I'm going to sort of address like what to do when schools don't do this, and we can take any remaining questions. So the first is suspending a student twice for the same thing. Districts can't do that. There are some districts where something happens, like let's say a kid is caught with marijuana at school, and the school sort of holds like a mini suspension hearing just with the kid, where they say like, what happened? What did you do? Where did you get this? The kid tells them, they say, okay, you're suspended for 10 days and we're going to call you to schedule an expulsion hearing. Then they secondarily schedule an expulsion hearing. And at the expulsion hearing, there's just no point to that second hearing because the child already confessed to everything at the earlier hearing or already said everything without the benefit of talking to a lawyer. Likely the child was under a lot of stress. And the Department of Elementary and Secondary Education has made things very, very clear here. If you can't suspend a child twice for the same thing, this idea that a child is sort of automatically suspended for 10 days sometimes when things happen, and then later we'll schedule an expulsion hearing, can't do that. That's against the law. That's one thing that districts commonly get wrong. Another is not defining an exclusion as a suspension. So this is sort of related to something that we heard earlier, a question from someone saying like, what if they're saying, take your kid home, we won't count it as a suspension? Yeah. Districts can't do that. If they are excluding a child from the school prior to the end of the regular school day, it counts as a suspension. Predetermined hearings, I think we covered that. Emergency removals, we covered that. Mandatory re-entry meetings, sometimes districts tell kids, go home and don't come back till you can come back with a parent, or they tell caregiver, your kid can't come back till you can come back with them. Can't do that. Kids have a right to be in school. Their right to be in school cannot be conditioned on their parents' availability to come to a meeting. Districts that sort of mandate this have got it kind of backwards. A meeting or a hearing is supposed to happen before the child is excluded, not after. And then lastly, I want to talk about automatic or sort of policy suspensions. Still, there are some school districts and charter schools who will say things like, if you get in a fight, we automatically suspend you for 10 days. Or if you bring a vaping device to school, you're automatically expelled. Or, anytime a child puts their hands on someone, we have to suspend them, or we have to emergency remove them. All of that is a violation of law. Districts are always required to use their discretion to think about whether or not suspension or expulsion makes sense in a particular case, not doing these sort of automatic policy mandated suspensions. Those are sort of just some common points that I wanted to make sure that folks are clear on. Any questions about any of that before I talk about like what to do when the district, when districts don't do this?
I do have a couple of questions.
Okay.
Related to what you've already covered. If the student has been found to be ineligible for special ed services, but they are in the appeal period or during independent educational evaluation, does that put a hold on things, or do they have to be determined as eligible before any kind of rights?
If they are found ineligible and you're seeking an independent evaluation, then they are not, then they do not get an MDR. So if they've been found ineligible and an independent eval is happening during that period, they don't get an MDR.
Okay. If the child is sent to an emergency room for unmanageable behaviors and evaluation for that behavior, and the child spends some days in the hospital, is that considered a suspension?
No. Good question. I'm glad someone asked that. No, that is not considered a suspension. The reason is that, we think about sort of mental health parity. So if a child fell down the stairs and broke their leg and needed to be taken to the hospital and then, was out of school for a little while because of their broken leg, we of course wouldn't consider that a suspension. So similarly, if the child has some kind of mental health crisis at school that requires hospitalization, that's not considered a suspension, that's receiving medical care.
Okay, one more. Is it enough for the school to simply offer parents the opportunity for a hearing when issuing an out-of-school suspension in the written notice, or is the school required to hold the hearing?
The school is required to hold the hearing.
Okay.
Okay, so then I just want to note, of course, we know that schools don't always.
Oh, sorry about that, folks.
No. We know that schools don't always do this, that they don't always follow the law. So I just want to make sure that folks know a couple of options that you can use to hold schools accountable. So one thing to know is you can always reach out to me. I'm not actually sure if my contact information is on this PowerPoint, but it's certainly on some of the handouts. Eileen has it. You're welcome to get in touch with my office at GBLS if you have specific questions about specific cases. So that's number one. Number two is folks may be familiar with PRS. The Department of Elementary and Secondary Education runs a compliance system called the Problem Resolution System. If you just Google DESE PRS MA, it'll be the first thing that comes up. And you can now file a PRS intake online, which is handy. And basically the way this process works is there's a basic form. It asks, who are you? Who's the kid? Who's the district? And then it says, what happened? What did you do to try to fix it? Because DESE wants you to sort of give it a go yourself before coming to them. And then lastly, what do you want? What could the district do to fix this for you? So that first, the idea here is to allow folks to have some way to hold schools accountable without sort of going all the way to court. This DESE PRS process is fairly simple. It takes 60 days, start to finish. So you file your complaint, that's day one. Within maybe about 2 weeks, the department will send out what's called a request for a local report to the school district. Well, they will say to the school district, hey, school district, we got this complaint. What do you have to say about it? Please give us your side of the story, plus any relevant documents. Then you'll have an opportunity to talk with the DESE staff member who's investigating the complaint. And then again, within 60 days of your filing, the department will issue a letter of finding the school compliant or non-compliant. And if they find them non-compliant, they will order the district to, as best as they can, make it right. So maybe that means if a child was unlawfully suspended for many days, that child is going to be entitled to compensatory education. Maybe that looks like tutoring, like extra occupational therapy sessions, whatever makes sense for an individual student's case. So that's a second option, is going through PRS. A third option is the Bureau of Special Education Appeals. So if you have that kind of situation where there's an MDR and you think it's a manifestation of the student's disability and the district says it's not, one thing that you can do is go to the Bureau of Special Education Appeals and request either a mediation or a due process hearing. For a mediation, you do not need an attorney. You can go, I'm sure many of you have been to BSEA mediations, but when you go to a BSEA mediation, the mediator will ask you to explain what you want. They will ask the school district to explain why they don't think you should have it. Then the mediator will split the two of you up and try and help you come up with an agreement that day. If it's a situation where it seems fairly clear that it is the child's disability, a mediation can sometimes be helpful. The other option is to contact our office, and we can talk about whether or not I or one of my colleagues can represent the family in filing for a due process hearing to get that manifestation determination review result overturned. So that is sort of the bottom line, is if the district refuses to agree that something is a manifestation of a child's disability, the remedy that the family has is to file a due process hearing. And if you have a kiddo in that situation, I'm glad to talk more about it. So those are sort of the three things you can do. One is call us. A second is going to DESE and the problem resolution system. And the third is the BSCA. And I think we have, just a couple minutes left for any additional questions.
Okay. The student is being denied enrollment in a district because he is 20, has previously been homeschooled using an excuse of 48 months. Explain to them that it only applies if he's on an IEP. Where can I find the reg that would back this up?
So I can email it to you. Is there a way, Eileen, to get this person?
Yeah, I can email it.
Okay, I will email you I will email that to you.
Thank you.
Yeah.
Is there a time frame for having a hearing? When does it have to occur?
Like a school discipline hearing? We think that's what they mean, right? Yeah. So there is not a specific timeline saying, if the offense happened on Monday, the hearing must happen within some number of days. The exception to that is an emergency removal. So if a child meets the emergency removal standard and they are removed from school before the hearing happens, then the district has to hold the hearing within 2 days. 2 days. So if the child is out of school, the district has to hold the hearing within 2 days. Otherwise, there's not a specific time frame.
Okay. What if parents refuse to come to a meeting? Is the school then obligated to keep the child in school despite the disruptive behavior?
What if parents refuse to come to a school discipline hearing? And so is the school district required? No. If the district has made reasonable efforts to contact the family, so that means the state law says that means they have to reach out to the family at least twice to say, hey, we'd like to hold a hearing. Here's when we'd like to do it. And if the family says, we won't participate or we don't want to participate, the district is still obligated to go ahead and hold that hearing. But if the results of that hearing are that the student is suspended, then, that's the district can do that. So the family can't prevent the student from being suspended by refusing to participate in the hearing. But the district just has to make reasonable attempts to involve the family.
Can meetings be held over the phone with parents?
So we don't have a clear rule one way or the other whether or not hearings can be held remotely. Generally, my position has been that if the family requests that, and it is a meaningful hearing, then that's okay. I represent some families where for a parent with some kinds of physical disabilities, it's just extremely challenging for the parent to get to the school and they'd prefer to do it by phone. I think that's reasonable. If, however, the district does the thing where they call the parent and they say, hey, we'd like to suspend your kid. This is for how many days? Here's your verbal notice of the hearing. Let's hold the hearing right now. Okay, your kid's suspended. And I would say that kind of perfunctory phone call, that's not a hearing. So basically, to sort of summarize that answer, I think that if district is holding hearing over the phone at the request of the family and it's a real hearing, that's fine. If they're holding a hearing over the phone in order to avoid having a meaningful hearing, then that doesn't count.
Okay. Let's see, is there a time limit to file a PRS complaint?
Yes, so you have 2 years from the time of the incident.
Okay. And if you appeal to BSCA, do you have to notify the district of your appeal or just file with BSCA?
You will also have to send a copy of it to the BSCA.
Okay.
Or sorry, to the district. Yeah.
Great, thank you. Thank you so much, Elizabeth. That was a very informative presentation. Participants will be sent a survey, and we very much appreciate it when you can complete the surveys. We will also send out the PowerPoint from this presentation. We will be posting information about our April webinar shortly, which is going to be on supporting children on the autism spectrum in schools. Please feel free to call or email us at the Federation as we all deal with these challenging times if you have questions that come up. Thank you for joining us today. This is RTSC.
Thanks, folks.